Here we go. Thank you, everyone, for joining us for this evening's webinar. The Tug Hill Commission and the Association of Towns are pleased to bring you this newly elected officials training session. First of all, congratulations on being elected, and thank you for all the important work you're about to be doing to lead your communities. Second, if you're not familiar with the Tug Hill Commission, in a short nutshell, we're a very small, non-regulatory, state-funded agency that provides municipal assistance to the towns and villages in the rural parts of Jefferson, Lewis, Oneida, and Oswego counties. Our program staff are located in Watertown, New York, and we have field staff, we call them circuit riders, in each of those 4 counties. So if your community is in one of the Tug Hill's councils of governments, or COGs for short, you'll see them or their associates at your monthly board meetings. Our circuit riders are John Helt, Angie Kimball, Nikki Dietrich, and Paul Baxter. They're there for you, and get to know them. You'll be very happy you did. Quick shout out to John at the Northern Oneida County Council of Governments for elevating the need for this training and for helping us coordinate it. So last, certainly not least, we need when the need for a training topic of this importance and magnitude is required, we look no further than to our friends and associates at the Association of Towns of the State of New York to deliver this information. They're there for you too. So we're privileged to have Sarah Brancatella, Lori Mithen-Demasi with us this evening to lead this workshop. Sarah and Lori, thank you. Once I'm done, please feel free to tell us a little about yourselves and about the Association of Towns. 2 quick housekeeping items. You're all muted. Your videos are off to reduce the load on the internet. Use the chat function for any questions, and we'll monitor that as we go along. And last, the webinar is being recorded and will be available through our website and YouTube channel. So watch your emails for follow-ups with links to the videos. Lori and Sarah, you're up.
Thanks, Jennifer. My name is Sarah Brancatella. I am Legislative Director and Counsel with the Association of Towns. The Association of Towns is a membership organization. We represent the 933 towns across New York State. Some of the services that we provide are education and training for town officials, advocacy, so lobbying for town issues, like highway funding, general purpose funding, things like that. And we are 2 of the attorneys on staff. Today, we're going to start off our session with municipal ethics, because when we were looking over the attendee sheet, we noticed some people are not from towns. So municipal ethics is applicable to everybody. So we thought that we would start off with that. The second half of tonight's presentation will be more focused on town government, just sort of an overview of that. So if you are a village or city official, you're welcome to stick around, but it might not have as much applicability. But municipal ethics is for everyone. It is my favorite topic to present on. There are a lot of gray areas, which I hope that you will see. And yeah, Lori, do you have anything to add?
No, other than that ethics are important and fun.
Oh, also, I should mention, one of the things that when I say training and education at the Association of Towns, one of the things that you can do is email AOT or call AOT and ask for information, ask for legal information. We have 4 attorneys on staff. And if you are a part of a village or city, NICOM is the equivalent, the New York Conference of Mayors, that is the equivalent of AOT for cities and villages. And then there's NISAC too. Really, really wonderful people that we have the privilege of working with often. So every entity, every type of local government in New York has an association, and they're all filled with wonderful people. Maybe not as great as Lori, but really, really good. Anyway, without further ado, I'm going to start on municipal ethics.
Ooh, Sarah, while you're getting that going, can I just remind everybody to go to the nytowns.org website if you're looking for additional training. We do have a more in-depth newly elected school in January. There's one in Albany and one in Rochester. We do that with the Comptroller's Office, Department of State, Department of Health. There's lots of folks there. That's a little bit broader view and deeper dive on some of the topics that we're going to be touching upon today. And then we have our annual meeting in February if you want training on all kinds of topics and great networking opportunity.
Yeah, thanks, Lori. I forgot to mention that, so thank you for bringing that up. Okay, municipal ethics. I don't think that any of you got involved in local government because you plan on screwing over your residents and getting something for yourself. All right. What happens, especially at the local level, is that municipal officers can get in trouble because they are not familiar with what the rules are. And there are very specific rules, ethics rules, for what public officers have to follow. Topics that are going to be covered in this presentation include conflicts of interests in contracts, common law conflicts of interest. Common law refers to court-created law. So in New York State, in the American legal system, you have your statutes and you have case law goes through the court. Not everything is codified in a statute. So it's not everything isn't going to be like under Town Law Section 20, under Town Law Section 291. Sometimes it's a result of case law that has made its way up to the Court of Appeals or through the appellate level. So when I refer to common law, I'm referring to court-created law. You still have to follow it with the same vim and vigor as you would statutory law. It's just a different way of creating the law. Covering some miscellaneous general municipal law, Article 18 provisions, family, issues of nepotism, and when two members of the same family can work for a municipality. Dual office holding refers to when one person can hold two positions. And then I'm an attorney, I like to hedge, so I have miscellaneous, just, kind of like a catch-all. There are a few random provisions, gifts. One thing that I will not be talking about that you might have heard of is the Hatch Act. That's really applicable when you're running for office, not when you're in office. But if you've heard of that, not going to cover it. If you're in office, you're probably good. But just in case anybody was like, "Ooh, maybe she'll talk about the Hatch Act," I'm sorry to disappoint. It will not be the first or the last time that I do that. When I'm talking about municipal ethics, we all have our code. We all have our own internal code, our own system of beliefs, how we think we should live a correct and right life. With municipal ethics, I am not talking about that. I'm not talking about anything like religion. There's no sense of morality involved. When I'm talking about municipal ethics, I'm referring to objective principles under the law that define behavior as appropriate. So, as I said before, when a lot of people, when they get involved with local government to start, they get in trouble because they just aren't aware of the rules. They're not doing anything morally incorrect or, intrinsically something that we would all rankle at. It's just under the law, it would be considered unethical. So that is what I'm referring to. And ethics can act as both a sword and shield. They are used to protect the public from municipal contracts influenced by avaricious officers, but also to protect public officials. Because as some of you may come to find or have already experienced, and maybe you were this person, in public meetings, a lot of times you will have a resident come in and just accuse the municipality of doing something nefarious, doing something shady, right? And ethics laws are a great way. They act as a shield for public officers because that way you can say, "Oh, okay, great. That's just your opinion. You're totally entitled to it. However, I have acted in accordance with the law." And that's what's important. Also, just to start, I'm making a really big effort to keep saying like municipal and not town official. But if I fall back into that, if I fall back into the language of town, that's just because that's the currency in which I deal. But for the purposes of this presentation, when I'm saying town, I'm meaning every level of local government. Think of it as an omnibus term. So what are these objective sources of ethics? First, you have General Municipal Law, Article 18. It is the only state law on municipal ethics applicable to local government. It is a bad law. It is a bad area. It is, by that, I mean, it hasn't been updated significantly or substantively since, I want to say, the 80s. There are a lot of holes in General Municipal Law, Article 18. And throughout this presentation, I try to get to the point. I hope I illustrate the holes that exist. Common law, again, that's court-created law. Local ethics codes, every municipality is supposed to have a local ethics code. Take a look at it, ask your town clerk, ask your village clerk, take a look at your local ethics code. Every municipality is supposed to have one. Agency opinions are another source of ethics. Agency opinions, by that I mean opinions from the Attorney General's office or the New York State Comptroller's office. They are not like common law in that you are not required to follow them. It is not precedent. However, I really like agency opinions because I think that they serve as a really good canary in the mine, right? If the Comptroller's office says that something is a conflict of interest, it's a decent I want to say prognostication, which is a word, but not the best word. It's a decent indicator of how a court might rule. Also, let's say that, that resident comes in and accuses the town of doing something shady. And maybe you can say, hey, you know what? The Comptroller's office took a look at this at a similar situation, and they found that there was no conflict of interest. It's a great rational basis on which you can act on. Point two, your local ethics board, municipalities are not required, at least at the town and village level, you're not required to have local ethics boards, but you might have them. A lot of counties have them. They might actually be statutorily required, but I don't know. But there are local ethics boards. You might have one. What I like about local ethics boards is there's a lot of gray areas in ethics, and reasonable minds can differ. I think that's really important to stress, especially when you get into the grays. Just because people disagree, it doesn't mean that one person is right and one person is wrong. Two very reasonable people, very reasonable minds can look at the same thing and come up with different conclusions. In our office, Lori, the other attorney, Katie in our office, and I will often talk to each other and run ethics things. And we all look at it a little bit differently. So what I like about local ethics boards is that you have a meeting of the minds. You have 3 or 5 people, however many people are on that board, coming up with one determination. So that is, local ethics boards are great. If you have one, they can be a great resource. Talk to your town attorney. Talk to your municipal attorney, talk to other board members, see what their sense is. Call the Association of Towns, call NICOM, call NISAC, see if they can offer you any guidance on whether your proposed action or whether the action would be considered a conflict of interest under the law or unethical. So those are the objective sources of ethics. We are going to start off by going over conflicts of interest in contracts, which is a very specific type of conflict of interest. And the reason why we're starting with that is because that is the only conflict of interest that is covered under General Municipal Law, Article 18. That is one of the significant holes that exist in that area of law. But that is what we are going to start with. And to determine if a prohibited conflict of interest exists in a contract, I want you to look at 3 different sources. 1, GML Article 18, 2, your local ethics code, and 3, common law. Always, when you are looking to see if there is a conflict of interest in a contract, always start with GML Article 18. Always start there. Actually, with any sort of, if you're like, oh, if there is a conflict of interest, always start with GML Article 18. If there is a conflict of interest under GML Article 18 with a contract, your municipality cannot move forward with the contract. I will say that ad nauseum. If there is a conflict of interest under GML Article 18 in a contract, the municipality is not allowed to enter into that contract. Recusal is insufficient. However, let's say that it's not a conflict of interest under General Municipal Law, Article 18. Your inquiry isn't done yet because it might actually be a conflict of interest under your local ethics code. Let's say that it's okay under GML Article 18 and your local ethics code. Then you have to take a look at common law. And I am going to go through all of these things. We'll see. So to analyze if there's a conflict of interest in contracts, I have it down to a 6-question analysis because especially with ethics questions, I'm an emotional person. I feel like my hands are off the screen, but you might be able to tell that I'm gesticulating wildly. I am an emotional person. I have knee-jerk reactions. And I think with ethics, it tends to, it lends itself to having an emotional reaction. And that's when I like to put on like my robot attorney brain. And I think these 6 questions sort of take away the emotion of evaluating in ethics questions, and it makes it very, very, step by step. It takes the emotion out of it, and it lets you evaluate something with a clearer mind, keeping in mind the legal standard. So these 6 questions. Number 1, to analyze if there's a conflict of interest in contracts. Number 1, does the potential conflict lie with the contract with the town / municipality? Because remember, town here is an omnibus term. Number 2, if so, if there is a potential conflict with the contract with the town, if yes to 1, do you have an interest in the contract? If yes to 1 and 2, do you have control over the contract? If yes to numbers 1 through 3, do any statutory exceptions apply? 5, what does your local ethics code say? And 6, is there an appearance of impropriety or common law conflict of interest? I'm going to go through each one of these questions one by one, and you'll see that the first 4 questions are in red because that is how you analyze if there's a conflict of interest under GML Article 18. Those are the 4 questions that you ask for GML Article 18 analysis. So, question number 1, does the potential conflict lie with a contract with the town? For the purposes of GML Article 18, contract means claim, account, demand, agreement. It can be written or oral, express or implied. I don't want you to get too caught up on what the definition of contract is. I just want you to get that it is broadly defined. Sometimes people think that contracts have to be signed in blood, written down, but a contract could be something as simple. A contract is something as simple as going to the store and making a purchase. That is a contract. It does not have to be written down. So, pardon me, I'm getting over a little bit of a cold. So just keep in mind that contract is a very broad term. Something that is not considered a contract under GML Article 18 is a land use application. So an application for a variance, for a special use permit, that is not a contract under GML Article 18. It makes sense, but just it makes sense. Why? Because it's not like any sort of guarantee. There's no consideration. There's no remuneration, anything like that. But just we're not talking about ZBAs and planning boards here, because land use applications are not contracts, despite the fact that contract is very broadly defined. So question number 1, again, is there a conflict? Is there a potential conflict in a contract with the municipality? So here I like to teach by hypotheticals and examples. I went to Catholic school growing up, and that was how I was taught, and I think it is useful. So here's a hypothetical. A town board member hires a planning board member as their architect on a home reconstruction project. Is this contract prohibited by GML Article 18? Some of you might be like, how the hell are we supposed to know, Sarah? We're newly elected officials and you're like 15 minutes into this presentation. Go back to the 6 questions, right? The question number 1, is there a potential conflict with a contract with the town? Here, no, there isn't. Everybody wears 2 hats. Every public official wears 2 hats. You wear your public official hat and you wear your normal person. You guys are normal people too, not just town officials. So you have your hat as a public official and you have your hat as, just your everyday resident, your person. So here you have a contract between a town board member and a planning board member, but in their normal capacity, in their average Joe capacity. It doesn't have anything to do with the town. There is no contract here with the town, and therefore GML Article 18 is not going to prohibit this contract. You still have to take a look at your local ethics code and to see if there is a common law conflict of interest, but for this, GML Article 18 is not going to apply. Question number 2, do you have an interest in the contract? An interest is a term of art, which means a direct or indirect financial or material benefit received as a result of the contract. Under GML Article 18, you have an interest in the contract if your spouse, minor child, or dependent has an interest in the contract. There are exceptions for contracts for municipal employment. Members of the same family can work for the same municipality, but I like to think of it as if your spouse has a conflict of interest in a contract, you step into the shoes of your spouse. You are considered to have a conflict of interest. If your minor child has a conflict of interest in a contract, again, you step into the shoes. Same is true if your firm, partnership, or association where you work or are a member has a conflict of interest, or has an interest, you are considered to have that interest. That seems like a very broad statement, and I'm going to scale that back when we get to some of the statutory exceptions. Also, a company where you are an officer, director, employee, or stockholder has an interest in a contract, you are considered to have. You step into the shoes. Again, that seems very, very broad, and I'm going to scale that back when we get to the statutory exceptions, because then you might be like, well, how is the municipality able to enter into any contracts, especially in smaller communities? You know, everybody knows everybody. Yeah. Going to scale that back. But just so you know, again, interest is a financial or material benefit derived as a result of the contract. If your spouse, minor child, dependent, firm, partnership, association, wherever you work, if you have 2 jobs, if they have an interest, you are considered to have an interest. If you have an interest in the contract, even before you evaluate if there is a conflict, if you have an interest, under GML Article 18, you are required to disclose the fact that you have an interest. You are supposed to do it in public, submitted in writing, and given to your immediate supervisor or governing board. It is suggested that you do this even if a statutory exception applies. So even if it's not a conflict, again, you should still disclose just the fact that you have an interest. There doesn't necessarily have to be a conflict. I'm going to take a sip of water for a second. Okay, some more hypotheticals. The town wants to build a new town hall. Could the following contracts be covered by GML Article 18? So the town wants to buy a new town hall and they're thinking about contracting with a construction company owned by the supervisor. Let's go through our analysis here. Question number 1, is there a potential conflict in a contract with a municipality? Yes, you have a potential contract between this construction company and the town. It involves a municipal contract. Question number 2, does the supervisor have an interest in the contract? Again, interest being material or financial benefit derived as a result of the contract. Here, it seems fairly obvious that yes, a construction company owned by a supervisor, the supervisor would be considered to have an interest in that contract. What about the town wants to build a new town hall and they are thinking about contracting with a construction company that is owned by the adult son of the supervisor? Question number 1, do you have a contract with the municipality? Yes. Or do you have a proposed contract with the municipality? Yes, you do. Question number 2, does the supervisor have an interest in the contract? This is a trick question because if you recall, I did say that you step into the shoes of your spouse. If your spouse has an interest, you are considered to have an interest. If your dependents have an interest, you are considered to have an interest. But note, I said your minor children. So this rankles people, right? And here I specifically said an adult son. There might be circumstances where the supervisor could potentially be considered to have an interest. Let's say that the adult son lives with the parents and there's some sort of financial arrangement, lives with the supervisor, and like there's some sort of financial arrangement where if this contract were granted, the supervisor would actually derive. But just the fact that it is the adult son, yeah, no, let's say that it's like a pretty standard relationship. The adult son has their own life, you know, there's no financial benefit. There's no intertwining of finances or anything unusual about this. Here, GML Article 18 is not going to cover that construction, like this contract with the construction company owned by the adult son. That is a hole that exists in GML Article 18. It seems wrong. It feels wrong. It feels like this has the high potential for machinations, for chicanery, for something shady. This is going to be filled by common law conflict of interest, but this is definitely one of the holes that exists under GML Article 18. The third question to ask is, do you have control over the contract? And control means that individually or as a board member, you have the authority to negotiate, draft, authorize, or approve the contract, authorize payment under a contract, audit bills or claims, or appoint somebody with any of those powers or duties. more hypotheticals. I know that you guys are all really excited about that. But let's say the town is building a new town hall. Does GML Article 18 apply to a contract between the town and the town clerk's spouse who owns a construction company? Question number 1, do you have a proposed contract with a municipality? Yes, you do. Question number 2, does the town clerk have an interest in the contract? You step into the shoes of your spouse. So the spouse has an interest in the contract. There's the opportunity to financially or materially benefit as a result of the contract. You step into the shoes. The town clerk is considered to have an interest in the contract. At this point, he or she should disclose the fact that they have this interest. Remember that. Question number 3, does the town clerk have control over the contract? Again, control, negotiate, draft, authorize, approve, authorize payment, audit bills or claims, or appoint somebody. The answer is no. The town clerk does not have the authority to do any of those things. They are involved in some administrative work in terms of auditing claims, but they are not the ones who are actually approving them. So therefore, this contract is not going to be covered by GML Article 18 because the town clerk does not have the level of control that is required. Second hypothetical, a highway employee has a plumbing business. Does GML Article 18 prohibit the town from contracting with him for plumbing services? Question number 1, potential contract with a municipality. Yes. Question number 2, does the highway employee have an interest in the contract? Yes. The highway employee should disclose that fact. Does the highway employee have control over the contract in their capacity as a highway employee? No, highway employees do not get involved in auditing, signing, executing contracts. Nope. So there's no level. GML Article 18 is not going to prohibit either of these contracts. Question number 4, does a statutory exception apply? And GML Section 802 contains the full list of exceptions. I'm only going to go over a few of them that are more pertinent. There's a whole bunch of them, but these are some of the more common ones. So pre-existing contracts, but no renewals. What do I mean by that? Let's say that I have a contract to deliver salt to the highway department. I have had such a great time doing this that I decide to run for office, okay? And this contract is supposed to expire in May of 2024, and I just won my election in November 2023. Pre-existing contracts but no renewals means that once I get on the town board, the town can continue this contract until May of 2024. However, it cannot renew that contract because I've got interest, I've got control, there's a contract with the municipality, and this exception only allows it to continue to its end, that contract's end, but it does not allow for a renewal. Stockholders under 5%. So if you recall, I said that if you own stock in a company, you are considered to have an interest in that company. You step into the shoes. So this would be if you have stock under 5%, I always like to use the example of, I really like Diet Coke. I drink a lot of Diet Coke. And let's say that you have stock in the Coca-Cola company. If you have over 5% stock in the Coca-Cola company, my first question is, what the hell are you doing in local government? Because I feel like that would be worth a lot of money. I would probably be on a beach somewhere, not getting involved with local government. But if you had, let's say, 6% stock in Coca-Cola, that would mean that your municipality could never buy Coke products. If you own 1% stock in Coca-Cola, then this is one of the exceptions that would apply, and you would be able to purchase the sweet nectar of the god that is Diet Coke for your municipality. Contracts under $750 annually. That is an aggregate amount. So it's not like you would be able to your municipality would be able to enter into a contract for $50 here, or $749 here, $749 the next month, $749 the next month. No, it's $750 from the same vendor annually in an aggregate amount. A contract with a membership corporation or voluntary nonprofit corporation or association. I like to call this the volunteer firefighter exception, especially in the North Country. You might have we find that volunteer firefighters tend to get involved with local governments and get on boards. And we have talked to many town boards where a majority of the board members are in fact volunteer firefighters. If this statutory exception didn't exist, then it would be really hard for a municipality to contract for fire protection services. So this, if you just think of this is the volunteer firefighter exception, you are allowed to contract with volunteer fire companies that provide services for the town, even if those volunteer firefighters are also on a municipal board. Remember too, I said that if your employer has an interest in a contract, you are considered to have an interest in the contract, and that I would scale that back during the statutory exceptions. So here we are. An officer is employed by a company, but does not receive any payment from the contract and does not have any part in procuring, preparing, or performing the contract. That would be considered a statutory exception. And a good example of this would be a town board member works at a local auto parts store where the town highway department purchases items. His duty as an employee do not include any procurement, preparation, or performance of any of the town orders. He is paid a salary and does not receive any compensation related to sales to the town. That is an example of where the statutory exception would apply. But let's change the fact pattern a little bit, because a lot of times ethics questions really depend on small details. They're very fact specific. So let's change this a little bit. And let's say that at the end of the year, this person receives a bonus based on the total amount of sales like that the auto parts store has during the year. Then they are in fact receiving they're receiving money. It could be equivalent to $5, guys. There is not a de minimis amount that is listed in GML Article 18. It is a draconian mistress. It says that if you receive any sort of benefit in this circumstance, that does not, no good. So this, again, very fact specific. If he received any sort of compensation related to any sales to the town would not be able to purchase anything from that auto parts store, because remember, if there is a conflict under GML Article 18, your municipality cannot enter into the contract. Do not pass go, do not collect $200. You simply cannot enter into the contract. So I have it here again in bold. If you have a municipal contract, if you have interest, if somebody has an interest in the contract, if they have control over it, and no statutory exceptions apply, that means the municipality cannot enter into the contract. Recusal does not cure a GML Article 18 conflict of interest. Another way that I think of it is the poison, if you will, exists with the contract itself. It doesn't exist with the person. So recusing yourself is not going to remove the issue. The contract is going to lie, or the issue is going to lie. The conflict is going to lie with the contract itself. Conflict under GML Article 18, no contract, no good. Competitive bidding. These are like, we get these questions. Competitive bidding does not cure or excuse a GML Article 18 conflict of interest, nor do emergencies. So got some more hypotheticals here. The supervisor owns I actually love this example because it is something that it's a real life example. I actually got a phone call from a supervisor with this exact scenario. So the supervisor owned a flood service company. There was a major storm in the town and the town hall started to flood. And the town supervisor coincidentally owned this business, like a flood service business. I don't know. I don't have practical knowledge, guys. I'm a lawyer. So I can tell you what the law is, but I don't, flood service business. I don't know. He had a business that would be able to help the town out and save the town a lot of money, right? Because there was going to be significant damage done to town hall if this flooding continued. And the supervisor was like, great, my business can take care of this. Really was thinking of the town, not thinking about like, haha, how can I get money for myself? The supervisor's business was the only one around that can address the issue immediately. Is this contract prohibited by GML Article 18? Question number 1, do you have a proposed or potential contract with a municipality? Yes. Here you have a potential contract. Again, doesn't have to be in writing, okay? Can be implied. Here you have, yes. So here you have a potential conflict with a contract with a municipality. Question number 2, does the supervisor have an interest in the contract? Interest being a material or financial benefit as a result of the contract. Yes. Owns the flood service company. Question number 3, does the supervisor have control over the contract? In their capacity as supervisor, they do have the authority to audit claims, negotiate contracts, everything like that. Question number 4, do any statutory exceptions apply? No, they do not. As I said before, emergencies do not actually, they're not an exception to GML Article 18. So the supervisor in this scenario was like, well, crap, I really meant to do the right thing here. I wanted to do what was right for the town. And how this ended up getting resolved was I asked the supervisor, how much were the services that you provided? And it was around $3,000. And I said, would you be willing to take $749? Because then you have the statutory exception and the town would be allowed to enter into the contract. What the supervisor should not do is participate in any auditing of claims or anything like that. They should recuse themselves. But that is, if it were under $750 annually, that is an opportunity to have a statutory exception apply. The town would be able to enter into the contract, and then there would not be a conflict of interest under GML Article 18.
Sarah, we have a question.
Yes.
What if the supervisor didn't accept any payment for his services?
Yeah, that's also a way to get out of it. That is also a way to avoid a conflict of interest. Yeah, I mean, here in this scenario, he's like, oh, it's $3,000. He didn't have to accept payment, but yeah, if there is there would not, receiving no payment for that would also remove it from the GML Article 18 conflict of interest. So what are the effects of entering into a contract despite the fact that there is a conflict of interest under GML Article 18? First thing, I mean, everybody wants to know about the consequences, right? The first thing that is not listed in the law, but I think is very important, if not the most important thing, it is the erosion of trust in local government. Never discount that as an impact of acting despite the fact that there is a conflict of interest. All right, you guys are the level of government's closest to the people. You live in your communities, you see people in the grocery store. Don't do it. Okay, you're just going to do a good job. Don't erode trust in local government. But so what are some of the actual consequences? Effects of violation. A willful violation would be that the contract would be considered null and void and payment would be prohibited. A willful and knowing violation could be a misdemeanor. What is the difference between a willful violation and a willful and knowing violation? A willful violation is nobody's holding a gun to your head, okay? You are entering into the contract not under any sort of duress or coercion. You are willfully acting. Willful and knowing is acting not under coercion or duress, and knowing that you're not supposed to, okay? There's the element of intent, there's the element of knowing there, and acting and knowing that you're not supposed to is worse, and that would be a misdemeanor. The example that I gave with the supervisor in the flood situation, his would be considered a willful violation because he didn't know that he wasn't supposed to. He wasn't like, well, I'm going to do this anyway. And also, let's be real, in that particular situation, let's say that he even did know that it was a violation under GML Article 18. In the real world, I'm kind of like, what DA's office is going to pursue that as a misdemeanor? But again, don't discount the fact that you are eroding the public trust if you are acting if you are acting when there is a conflict of interest. So those are the consequences under GML Article 18. To close out the GML Article 18 analysis, I have some more hypotheticals because I really like to drill this home, you guys. And I just think that hypotheticals are the best way of illustrating this. So here you have a town that is celebrating its bicentennial, and it wants to commission an artist to create posters for the celebration. The total cost of the project would be $700. The wife of a town board member is a well-loved local artist who would do a great job. Can the town hire the wife of the town board member to create these posters? Question number one, is there a potential contract, or is there a contract with the municipality or a potential contract with the municipality? Yes. Question number two, does the town board member have an interest in the contract? You step into the shoes of your spouse. So the spouse has an interest because they have the opportunity to materially or financially benefit as a result of the contract. Thus, the town board member has an interest. The town board member should disclose that fact. Question number three, does the town board member have control over the contract? Yes, as a town board member, you do have the authority to authorize, negotiate, audit claims under contracts. So yes, does have a level of control or does fit the definition of control. Question number four, do any statutory exceptions apply? Yes, in this situation, they do, because as I mentioned before, $750 annually. What the town couldn't do here is hire the wife of the town board member for this bicentennial, and then a few months later, hire them for $700 on another project, okay? Because remember, it is $750 in the aggregate annually. So this would pretty much max that out for the year. But yes, GML Article 18 would allow for this contract to move forward. Hypothetical number two. The town solicits bids on a new truck. The lowest responsible bid is from a dealership owned by Griffin, the husband of town board member Matilda. Can the town purchase this truck? Griffin is the name of one of our colleagues' dogs, and Matilda is my cat. If you continue to do webinars with AOT, you will hear more about my cat and possibly see her. I am the cat lady. Anyway, question number one, is there a potential contract with a municipality? Yes. Question number two, does Matilda have an interest in the contract? Yes. Material financial benefit, step into the shoes of your spouse, right? Question number three, does Matilda have control? Yes. She does, has the authority to audit claims, negotiate, all of that stuff. Question number four, do any statutory exceptions apply here? Out of any of the ones that I went over, it is highly unlikely that this new truck is going to cost less than $750. And remember, I said that competitive bidding does not excuse a conflict of interest. It is not a way to get out of it. So no, the town would not be able to purchase the truck from this dealership. Hypothetical number three, and I promise I am building up to stuff here. And there's a reason why I use this specific hypothetical. And you're probably like, sick of hearing about this new town hall, but there's a reason. Okay, hypothetical number three. The town is building a new town hall. The town board wants to contract with a construction company. The construction company has a separate contract with a steel supply company that is owned by the town supervisor. Is this prohibited by GML Article 18? So I want everybody to understand the construct here, okay? You've got the town is going to contract with a construction company. The construction company has a separate contract with a steel supply company, and the steel supply company is the one that is owned by the supervisor. Question number one, is there a potential contract, or is there a potential conflict in a contract with the town? This is a trick question because GML Article 18 is only concerned about this contract here. It is only concerned about the contract between the town and the construction company. It is not concerned with the contract between the construction company and the steel supply company. So here you have a situation where potentially the supervisor could, as a matter of fact, receive a financial benefit, have an interest in the contract, and actually has control over the contract. GML does not cover this situation. It is not prohibited by GML Article 18. And some of you might be like, this feels wrong. It is a hole that exists under GML Article 18. And And that is why we do not stop our analysis at, is there a conflict of interest in a contract under GML Article 18? You have to go on. You have to take a look. Question number 5, does your local ethics code apply? With the steel supply situation, there might actually be something in your local ethics code that would address it and say, if the supervisor had to recuse him or herself, or if the municipality was allowed to enter into the contract at all. So always look at your local ethics code. Let's say that you take a look at your local ethics code. I have found in my experience, sometimes they are not entirely comprehensive. Maybe they haven't been updated since the 1970s, whatever. There's a myriad reasons why it might not be covered in your local ethics code. So then what do? Then you have to ask question number 6. Is there a common law conflict of interest that is sometimes referred to as an appearance of impropriety? The appearance of impropriety comes from the courts looking at GML Article 18, there not being a conflict of interest under GML Article 18, and the court saying that just doesn't feel right. The first time it came up was from a 1979 case, and the appearance of impropriety doctrine has really evolved over the last 44, over the last 40 some years. It's really evolved. And initially, this is from the original case in 1979, and it says government officials must maintain public confidence in the integrity of government. They must avoid even the appearance of impropriety. The test to be applied is not whether there is a conflict, but whether there might be. It is the policy of the law to keep the officials so far from temptation as to ensure his or her unselfish devotion to the public interest. This seems like really, really lofty language, and it doesn't offer a ton of guidance. Also, something to keep in mind is appearance of impropriety and common law conflicts of interest apply to more than just contracts. I was so contract focused on GML Article 18 because that's all that GML Article 18 applies to. It only applies to contracts, but common law conflicts of interest apply to everything. It applies to land use applications. So for example, a variance application is not a contract under GML Article 18, as I said before. However, a ZBA member is still subject to common law ethics standards. I like this next slide because I'm not a technological maven, but I made this graphic. So you'll see that GML Article 18 conflicts are just a very small subset, and common law conflicts of interest encompass a lot more. From the lofty language of, is there an appearance of impropriety? It is unselfish devotion, blah, blah, blah. How do you evaluate that? I like to break it down into 2 questions to determine if there is a common law conflict of interest. Number 1, is the interest personal? And number 2, is the interest substantial? Is the interest personal? That's the more straightforward question. It's pretty easy. A personal interest isn't one that you share with the public generally. It has to be very specific to you. For example, a town board member residing in a sewer district can vote on things like sewer rates, assuming that it is not a sewer district with just his or her property in it, okay? Living in a sewer district, we're assuming that there are multiple properties within that sewer district. That is an interest that they share with other property owners, within that district. So it is not considered a personal interest. When I'm talking, is the interest personal, is really like, is it very specific to you? Not just you as part of the community, not you generally, but is it very unique and specific to you? The more difficult question, and where there are more gray areas, is the interest substantial? And here we have, next slide. Okay, here we have my favorite case of all time, and I love this. And this is why I kept using like the steel supply, like building a town hall example. So here you had a planning board chair that owned a steel supply company that contracted with an applicant appearing before the board. The contract amounted to, actually, this is like 0.15% of his company's gross sales for the past 2 years. The neighbors argue that the chair should have recused himself. So again, you've got your planning board chair, okay? You have somebody appearing, you have a company appearing before the planning board, and you have this steel supply company that has a contract with the applicant, and the steel supply company is owned by the planning board chair. is this a is this considered a conflict of interest? Remember, land use applications are not contracts under GML Article 18. So this is not going, GML Article 18 is not going to apply. You should take a look at your local ethics code. If we were in person, I would say, how many people think that this is a conflict of interest? And hopefully about half of you would, and half of you would not. I left out some critical information here, and that is, what does 0.15, what does 0.15% of companies' gross sales for the past 2 years amount to? And here it amounted to $2,000. What happened in this case was it went to the local ethics board, and the local ethics board said, hey, we think that this is such a de minimis amount. We think that this is such an insubstantial amount of money that it is not going to impact the planning board's ability to remain impartial. Somebody wrote to the Attorney General's office, and the Attorney General's office was like, oh, no. It is the policy of the law to remain, so, unselfish devotion. The standard is if there even might be an appearance of impropriety, not whether there is a conflict. So the Attorney General's office was like, yeah, no, there's definitely a conflict here. It went to Supreme Court, which is the lowest level of court in New York State. And the Supreme Court said, yeah, we think that there's a conflict of interest here. It ended up at the appellate division. And the appellate division said, we do not believe that $2,000 is substantial enough. Based on the very, very specific circumstances of this case, we do not think that 0.15% equaling $2,000 is enough to impact the planning board chair's ability to remain impartial. Therefore, we do not think that there is a common law conflict of interest. Let's say that it was 0.15% of the Coca-Cola company, and it ended up being worth millions of dollars. That might tip the scale more towards, hey, that actually is a substantial amount. A few million might be viewed a little bit differently than $2,000. So the court didn't have a bright line test. It didn't say, okay, $2,000 is the limit, and then anything above that is considered substantial, and anything below $2,000 is insubstantial. It looked very closely at the very specific facts of this case. And I love this case because I think it is a perfect example of how things are very fact specific, and you really have to look carefully at the circumstances as they exist. And it perfectly encapsulates to me that reasonable minds can differ. It's not that the ethics board and the appellate division were right and the Attorney General's office and the Supreme Court were wrong. It's just that the appellate division had the buck stopped with the appellate division. They had the last say. All right, everybody was of reasonable mind, and there were differing opinions, and it just happened that the appellate division was the one that had the final say in this. But I love this case.
Sarah, you've got a question which you may be addressing later on, but I'll ask it now because it came up during your discussion of this case.
It's also a great opportunity for me to take a sip of water. So, right.
The question is, what about voting on amendments to a local building code that would cost the board members company money?
That would cost the...
Right, so I'm assuming here that they're considering a change to the local land use code that's going to impact the commercial business of a board member.
Yeah, I mean, okay, so is that so again, I'm not a member of Mensa, right? So I like to go back to just take off the emotional hat. So when you're dealing with a common law conflict of interest here, potential common law conflict of interest, is the interest personal? Is it personal and specific to the town board member, to the board member? It sounds like in this instance, it would be, it's a unique situation specific to them. And then the question would be, is it substantial? And that is where you fall into the grays. How much money would they be standing to lose? Would an objectively reasonable person think that the amount would be enough to impact the board member's ability to remain impartial? That might be a good question for ethics boards. I mean, also take the temperature of what the rest of the board thinks. ask the town attorney. I think that is an instance that is a really great question. And I think that is an instance that is very fact specific, and you would have to take a look and see, is the interest substantial? What's considered substantial there? Is it going to be, they're going to lose $5 or they're going to lose $100,000? Because that's a big difference. If it's going to be $5, probably, I'm going to go ahead and say probably not substantial, probably not a common law conflict of interest. The bigger the amount of money, the more likely it is to be considered substantial.
Do you also look at it in terms of percentage of annual or overall compensation, like in the Steele case, where maybe it was a large amount of money, but percentage wise, it was not much in comparison to the overall value of the contract?
Yeah, I mean, how you want to evaluate what's considered substantial. Substantial is a subjective term. If whatever, you should have a justification. If you want to argue that it's not substantial, then you could say, hey, if you look at like the percentage, it's only 0.1%. But again, here, the court focused on the fact that 0.15% only equaled $2,000. 0.15% of another organization might be worth millions of dollars. And that seems like it's more likely to be considered substantial in that instance. So I think that you have to take a look at a variety of different things, the overall percentage, the actual dollar amount, things like that to make that evaluation if something is considered substantial. Also, in that example, we're talking about dollars and cents, but substantial is not always going to be a quantifiable term. Substantial can relate to relationships. How substantial is your relationship with somebody? So for example, the neighbor of a planning board member applies for a special use permit. Whether there would be a common law conflict of interest warranting this planning board member to recuse him or herself depends on the circumstances. Let's say that this is a neighbor that lives about a mile down the road. Okay. I see them. I'm on the planning board. My neighbor's lives a mile away. I see them every once in a while. I know that they exist. Maybe I'll wave hello. But we don't really have any interaction. And the special use permit isn't going to be what the special use permit is about. It has nothing to do with my property. It's not near my property, whatever. That is less likely to be considered a substantial relationship that would impact my ability to remain impartial. On the other hand, let's say the circumstances were different and I'm from Buffalo. That is also something that if you talk to me for 5 minutes, I will say I'm from Buffalo and I love cats. But I'm from Buffalo. I'm originally from Buffalo. I live in Albany, in the capital region now. That's where AOT is located, but I'm a huge Buffalo Bills fan. I grew up 2 miles from the stadium. I am ride or die Buffalo Bills fan. Let's say that my neighbor, who also grew up in Buffalo, is a huge Buffalo Bills fan, and we watch games together and, experience pain for 17 Sundays out of the year by watching the Bills lose miserably and shoot themselves in the foot or lose in the most heartbreaking fashion imaginable. Such is the life of a Bills fan, right? It's my birthright. I can't get out of it. But let's say that I'm really close with my neighbor and we are best friends. We hang out all of the time. We've got a really great relationship built around the Bills and other things, love of cats. If I'm on the planning board and that neighbor comes before the planning board, that is more likely to be considered a substantial relationship. I know in smaller communities, I want to be clear too, that just because you know somebody doesn't mean that you have a substantial relationship. Especially in smaller communities, you're going to know everybody, right? You really have to you individually have to evaluate the level of relationship that you have with somebody to make that determination if it is substantial enough of a relationship that it would impact your ability to remain impartial. I have first cousins that I would not be able to pick out of a lineup. Okay. If that cousin appeared before the planning board that I was on, the mere fact that they are technically a blood relation, that does not automatically make it a substantial relationship. Okay. I would not be able to pick them out of a lineup. You really have to look at the facts and circumstances, not necessarily the title. Another way to think of substantial is the interest more than speculative and more than a de minimis interest? Is there some meat to it, some oomph? A couple of cases that I think highlight that not everything is going to be considered a conflict of interest, a common law conflict of interest, is this case, and it involved Cornell University, and it had a proposed project that needed a series of permits, and it applied to the town board for rezoning. The court said that there was no conflict with a town board member married to a Cornell retiree receiving pension benefits from the university. The court really looked at the fact that the pension was a set amount, okay? It's not like the pension would be impacted, the pension amount, it would not be impacted at all if the town granted or denied these permits. It would have no effect on that. If it did, that is way more likely to be considered a significant interest. Also, the court said that there was no conflict with a town board member who was a graduate student at Cornell. However, it was very specific to say, very careful to say that, or take note that this graduate student was in, like, let's say the English department, and the department or college that was looking for these permits was like in physics. Okay, totally unrelated. This graduate student would had there was no nexus between the division of the university that was applying for the permit and this graduate student's program. If there were, that would make it far more likely that the town board member, graduate student, should recuse him or herself. Another example that I love here, the petitioner had claimed that there was a conflict of interest on the ZBA and a special use permit because the wife of a ZBA board member taught piano to the applicant's daughter and was given a Christmas gift for doing so. Also, the mother-in-law, those pesky mother-in-laws of a ZBA member, had spoken out against the project. The court said that the assertion that there was a conflict of interest here, a common law conflict of interest, the language that they used was mere speculation, but the subtext to it was basically like, are you kidding me? A wife teaching piano and getting a small Christmas present, like a Tim Hortons gift card, is not substantial enough to impact somebody's ability to remain impartial. In general, courts are going to find a conflict if there's a financial or material benefit involved for a public officer or for one of their families, but not always. Remember the steel supply company case, that's the town of Gardner case. In that case, there was a financial benefit, but the court said that it was such a small amount, $2,000, 0.15%. But overall, if you take a look at the development of case law since 1979, they are more likely to find a common law conflict of interest if there is a material or financial benefit. When there is the appearance of a problem, but the court thinks that a public officer is able to remain objective, they're less likely to insist on that individual recusing him or herself. And getting to recusal, the Attorney General advises that if there is a common law conflict of interest, that an officer should recuse themselves in public on the record, and recusal should prohibit you from discussing, deliberating, and voting on the matter. Okay, abstentions are, this is on the next, I do have it on the next slide. Recusal versus abstention. A recusal should be more enveloping, a bigger umbrella than abstaining. Abstaining is just not voting. Recusing is removing yourself from the entire conversation so that you do not influence the process. You should disengage entirely. I cannot tell you how many times we have phone calls where a board member might recuse himself or herself, and they get off from around the table, the dais, and they go, and then they just sit in the front row and they give the stink face. Okay. Or maybe they have participated in conversations up until the last minute, and then they're like, oh no, there's a conflict of interest, we have to recuse ourselves. No. As soon as you're aware that there's a conflict of interest, that there is a common law conflict of interest, you should recuse yourself. There's no legal definition. There's no state definition for what constitutes recusing yourself. Your local ethics code is a great opportunity to clarify what is required when you are going to recuse yourself. Great opportunity. So I strongly recommend that provision. Also, keeping in mind, that not everything is going to be a conflict of interest, or if you recuse yourself, it does impact things. If you recuse and do not vote, that is always going to have the functional equivalent of a nay vote. What do I mean by that? So let's say that you have a 5-member board, you have 2 people vote yes, 2 people vote no, and 1 person recused themselves. That vote, that recusal is never going to be counted as a yes vote to get that quorum needed, to get the majority of the board needed to pass something. It is never going to be counted as a yes. It is going to have the functional equivalent of a nay vote. What are some of the consequences despite acting an appearance of impropriety, or despite acting when there's a conflict of interest, a common law conflict of interest? Litigation, the action can be voided. Again, eroding the trust in local government, that's a big one. So yeah, I guess just another way of summarizing this is like going back to GML Article 18, evaluating if there is a conflict of interest. This is just a different way of that 6-question analysis. So number 1, is there a contract with the municipality? If there isn't, immediately go to check your local ethics code. If it's not covered in there, then evaluate common law. In evaluating common law conflicts of interest, that involves 2 questions. Is the interest personal? Is it substantial? Let's say you do have a contract with a municipality or a potential contract with a municipality, then you ask, do you have an interest in the contract? Do you have control over the contract? Does a statutory exception apply? And just go through all of that analysis. I do have a 1-page handout that lists all 6 of these questions, and I think that there's going to be a copy of this slideshow too. But yeah, I do have a 1-page handout that goes over, has this chart, has the 6 questions. I'll make sure to email it to Jennifer so she can distribute it to you guys afterwards. That is conflict of interest with contracts and like land use applications and just general stuff. I'm going to get into nepotism, but I'm going to check the time first because I don't want to step too much on Lori's toes going over welcome to local government. So quickly going over issues of nepotism, conflicts of interest with family.
Take your time, Sarah. This is an important topic. And I do have a question waiting on this area, family and appointments.
Okay. So there is no prohibition against members of the same family working for the same municipality. Some families are just born into public service, right? Very public service oriented. And it is not uncommon at all for, a wife to be on the town board and the husband to be the highway superintendent and the cousin to be the town clerk and the aunt to be the assessor. It is not uncommon at all. So there's no overall prohibition against members of the same family working for the same municipality. The general rule is that an officer should not participate in decisions concerning the salary, terms and conditions of employment. Oh my God, my cat just scared me. Sorry about that. Okay, the general rule is that even though members of the same family can work for the same municipality, you should not be involved in decisions about salaries and terms and conditions of employment. An example would be the wife is on the town board and the husband is the highway superintendent. In this instance, the wife should recuse herself from discussions and voting on the highway superintendent's salary. She can vote on and participate in discussions on general highway matters like equipment, the general highway budget, but should not vote again on the highway superintendent's salary. She can vote to adopt the highway budget as a whole, because that's not really a term and condition of employment. That's the highway budget overall. That's like town stuff, not specific to the highway superintendent. So here, when the town is developing the budget, the town should take out the highway superintendent's salary from discussions the town board member / wife should recuse herself. That means that she should get up and get out of the room and not participate in conversations, not officially, not unofficially, just do not engage. And yeah, that would be an example of that.
Wait, can I interrupt you before you go forward with gifts?
Yes. Also, Matilda is like zooming around all over the place. And that is why I'm like, what is going on here? And now she's right over here. Anyway, what is the question?
Maybe she'll make an appearance on screen.
One can hope.
Introduce her. So the question is, can the supervisor, for example, hire their spouse to be their administrative assistant? And does it matter if the person is only paid minimum wage? And then I'm not sure if this is the same question or a second question. Assume the position has existed under other supervisors. Does it matter if they have an adult child? Oh, if they are the adult child.
So okay. Let's assume that you're talking about the supervisor's confidential secretary or bookkeeper. And so then the supervisor has the sole authority to make that appointment. It's not the greatest idea I know that it happens. Okay. I know that it happens. It is not the greatest idea, or like, let's say that they're truly the best fit. I think a better practice would probably be to, even though technically statutorily it is the supervisor's appointment, I think a better idea in that circumstance would probably be to have the board sanction that appointment or agree to it and have the supervisor not discuss that appointment. But in any event, the supervisor should not be a part of conversations on how much that position should be paid. Does that make sense, Lori? Does that? Okay. Yeah, I know it happens. And actually, I know it happens a lot with town clerks often appoint their daughter, town clerks often appoint a relative to that position. It's not like, it's not great. It's a type of common law conflict of interest because it's considered substantial, right? Like that's a relationship that's considered substantial. But there are ways that I think that you can make it more palatable, as I said before, like with the supervisor situation and the confidential secretary or bookkeeper, even though statutorily it is their appointment. Again, if like the spouse genuinely is the best person for that position, then I think it is probably better to have the town like give that to the town board to make that determination. And again, should not participate in conversations on the salary for that position. Dual office holding, that is when one person can hold two offices. There is, again, no general prohibition against one person holding two offices, wearing two different hats within your municipality. However, there are 3 circumstances where there is not allowed. Positions are considered incompatible when one is subordinate to the other. Position A cannot be the boss of position B. There is a conflict of duties. I like to think of that as upsetting a system of checks and balances. You are reviewing your own work, or your duties are so inherently at odds with each other that one person would not reasonably be able to do them both, or otherwise prohibited by law. And by that, I mean that there is a statutory prohibition. Some examples of that would be a subordinate position. A town board member could not also be a highway laborer. Even though the highway superintendent has the authority under town law to hire and fire highway laborers, the town board is the one that sets the salary for that position. So if you are on the town board and you are also a highway laborer, position A cannot be the boss of position B. And because position A, town board member, can set the salary of your second position, position B, no bueno, not good. An example of a conflict of duties, again, like upsetting a system of checks and balances, reviewing your own work, would be a code enforcement officer should not also sit on the ZBA, because the way that works is, right, somebody's going to go to the code enforcement officer looking for a permit. Code enforcement officer is going to take a look at it and they're going to say, like, nope, you need a variance. It doesn't comply with this. So they do not issue the permit. Somebody will then appeal to the ZBA. That person will then appeal to the ZBA seeking a variance. And you would have essentially the code enforcement officer reviewing their own work. So that is an example of a conflict of duties, upsetting a system, reviewing your own work. Otherwise prohibited by law, there are a smattering of statutory prohibitions. Actually, just yesterday, I was asked about County Law Section 411, which says that you cannot hold an elected county office and an elected town office. Town Law Section 20 says that one person cannot hold 2 elected positions within the town. Town Law Section 260 something says that a town, pardon? 267. Okay, yeah. Town Law 267 says that a town board member cannot also sit on the ZBA. So there's not a ton of them, but there are a smattering of these statutory prohibitions. I hope that you were all taking a moment to take in these 2 gorgeous beasts that are on the screen. The tuxedo is the black and white cat. That is my cat, Matilda. The gray one is my late cat, Oaf. Sad. She passed away last year from whatever. But that I have an example of overcoming conflict because they are snuggling. And so there is this opinion from the Attorney General's office that says when there is a conflict, an issue of incompatibility between 2 different offices, there is a limited exception that is meant for smaller municipalities that says that you can overcome. So the Attorney General said that you can overcome this incompatibility of office by adopting a local law. It is supposed to be for smaller municipalities, and it is supposed to be for keeping in mind the best interest. It should be in the best interest of the municipality. So as I said, I'm from Buffalo. I'm from the Buffalo area. The town that I grew up in has a population of about 35,000 people. That is not an example. That is not a municipality that you can find somebody else to hold those 2 positions. However, smaller municipalities sometimes find difficulty staffing people. And a really good example of this is that there was a smaller town and this guy was the dog control officer and he really liked it. And he ended up running for town board and winning. And everybody loved him as dog control officer. You can't hold there is a conflict of interest. There is the position of dog control officer and town board member are incompatible because the town board has the authority to appoint the dog control officer. So it's an issue of subordination here. This is a recommendation. This is a best practice. This is not required, but this is what I recommend to establish that it is in the best interest of your municipality. My suggestion would be advertise for the position. Either nobody qualified is going to apply or nobody's going to apply, period. Advertise for the position a second time. Same thing is going to happen. Once you have established a record, you can say, hey, the town made a really good faith effort to find somebody else. Nobody else is qualified or available to fill these 2 positions to hold the position of dog control officer. So we are going to adopt a local law superseding, overriding this incompatibility of office for this specific circumstance because we believe it is in the best interest of the town. And that is what the town did there. They actually adopted a local law overcoming this conflict of incompatibility of offices. And so the one person was allowed to sit on both the town board and be the dog control officer. Obviously, he was not allowed to vote on his own appointment. Okay. But yeah, so this is an option available if you are having difficulty staffing, finding people. If you are a smaller municipality, you can overcome that incompatibility with a local law. But again, it's not required. I just recommend that you make a good faith effort to find somebody else. And that way, when you have that resident come in and complain and accuse your municipality of doing something super shady, you are able to say, hey, we tried. Like, we made a good faith effort. We did the best that we could. And we have determined that this is why it is in the best interest of our municipality to move forward with this, despite the fact that there is an issue of incompatibility. You know what? I thought that there was something weird. I have some more slides on nepotism and family that I apparently just put out of order. I obviously, whatever. Going back to conflicts of interest and family here, nepotism again, there are no state rules against two members of the same family working for a municipality. A town can establish its own policies and procedures when we're talking about two members of the same family working for a municipality. Your local ethics code can address nepotism, but there are no state laws currently in New York on nepotism. So, for example, in this nepotism policy, a town said that if you are related closer in degree by blood or by marriage than first cousin, and that person is seeking employment, then you just have to disclose the fact that you are related to this person. Some examples here. Linda is on the town board. Her husband, Vince, applies to fill a vacancy on the Zoning Board of Appeals. What should Linda do under this nepotism policy? They are related in degree. They are married. They do, so in this circumstance, Linda should disclose the fact that she is married to Vincent, and Linda and Vince are my mom's names. So Linda might not want to admit that she's married to Vince, but she should disclose the fact that she is married to Vince, and then she should not vote on that appointment. She should not vote on the appointment of her husband to the ZBA. Let's say that Carrie is on the town board. Carrie is my sister. Her long-term boyfriend, Kent, applies to be on the Zoning Board of Appeals. What should Carrie do under this nepotism policy? So here, again, it's not Kent is not actually going to fall under this policy. So Carrie is not obligated under this nepotism policy to disclose the fact that Kent is her long-term boyfriend. Should she, just as a good faith measure? Yes, she should. However, common law conflicts, if we go back to common law conflicts and standards, this is a substantial enough relationship that should warrant Carrie recusing herself. Recusal is sufficient to cure a common law conflict of interest. It is not sufficient to cure a GML Article 18 conflict of interest. So in this circumstance, Carrie is not required to disclose the fact, although I would recommend that she do that anyway, but she should recuse herself. I think.
Sarah, before you move forward, we did get questions on those two topics.
Okay.
One is unique to a village. I'm not sure if we can answer that. We may have to get back in touch with Tug Hill to get you the answer there. But the question is, can two spouses both serve as village board of trustees? They would be two elected offices. Or can spouses serve as a trustee and a mayor? Again, two elected offices.
I'm not aware of, unless there is a weird ass, I'm sorry, pardon my language, unless there is a weird provision under village law saying that, which I'm not aware of any, but since it is a village question, I'm fairly confident, but I'm not intimately familiar with village law. So unless there is a wonky provision in village law saying that spouses cannot serve, it seems like it would be okay, but I would check back with NICOM on that, just because I can't 100% say for sure that there is not a wonky provision.
And then the other question was dual office holding. Can one person work for both a town and a village simultaneously?
Yeah. Okay. So unless there's a statutory prohibition, or unless there is a conflict, you're reviewing your own work. Actually, it happens often. Like the town clerk might be a village trustee. That happens. There are circumstances where that would not be appropriate because there would be a conflict of duties. I think probably being on the town board and being a village trustee would probably be considered a conflict of duties because you would be potentially negotiating contracts on both sides. Lori, what do you think?
It's probably going to depend on the two positions in question.
Yeah.
Right.
Yeah.
So it's going to be an ad hoc analysis, and you'd have to go through all of your checklists, check Article 18, check common law, check nepotism policies, check ethics codes in both municipalities, and see, I think you mentioned the Attorney General's office opinions.
Yeah.
A lot of dual office holding and conflict of interest opinions have been looked at by the Attorney General's office. Sometimes their opinions evolve, but that's a good starting point. You could always check and see what are the two positions in question, and has the AG's office issued an advisory opinion on it? Or
Yeah,
ask
and
Sarah. Those are my approaches.
you can also always call AOT, call NICOM, talk to your town attorney. We can see if we can find if there's an agency opinion on that. But yeah, it really is going to depend on the positions. I think it is. Again, I think like the position of like town board member and village trustee, probably going to be a conflict of duties, probably going to be considered incompatible. But I know for a fact that like town clerk and village trustee are not incompatible. They are compatible positions. One person can hold both positions.
2 more questions have come in, and then we probably have to wrap up ethics.
Yeah. Oh, gee, Lori, do you want to speak?
We're pushing towards 7:30. Oh, so 3 questions came in. Okay, I'll take them quickly as I can. Can a town board member also serve as a paid park commissioner? So that would be an employee. Can a town member
Yeah,
also
I
be
mean,
an employee?
yeah, assuming that it's a park commissioner of the town.
I'm assuming so.
Yeah, no, because that's going to be a subordinate position. The town board is the one that sets salaries. The town board is the one that makes appointments. So you would have a situation where position A would be considered the boss or have a level of control over position B, and therefore would be incompatible.
The next question is, I think this is prohibited by town law section 20, but what happens when you run for town clerk, but nobody ran for tax collector, but you are written in for that position? So holding 2 elected town offices.
Yeah, that's going to be one of those rare statutory prohibitions because town law section 20 says that one person cannot hold 2 elected positions within the town.
So she'd have to choose which one of the 2 she wanted. Let's see. Would there be a conflict of interest if a village and a town of the same municipality both had the same attorney? So can the town and the village share the same attorney?
Yeah, short answer is yes, there might be some circumstances where, and that's a pretty common thing too. There might be some circumstances where you would have to get conflict counsel. So let's say that the village were negotiating like the village and town were negotiating an intermunicipal agreement and it was being done through the attorney, or like there was a sale between the 2 municipalities. Depending on the circumstances, the attorney might need to get a written waiver from both the village and the town, or might want to consider getting conflict counsel. But overall, that is not, yeah, that's okay. That's my opinion on that. I am going to not cover this particular topic, just go and say that ethics codes are a great opportunity to fill some of the holes that exist under Article 18. You can go over stuff like what's required for recusal, what are disclosure requirements when there is a conflict of interest, what type of conflicts of interest are prohibited. And then the last thing that I will say, and I can't find this slide, is there is a prohibition on receiving or soliciting gifts. It is General Municipal Law Section 805-A. Do not accept bribes. Do not accept gifts that look like bribes, that look like they're trying to influence you, okay? State law, section 805-A says that if it is worth over $75 and could reasonably be viewed to influence or try to influence your official duties, that is no bueno, and that could be considered a misdemeanor. As I said before, everybody has personal relationships. Let's say that your best friend gives you a bottle of wine that is worth $80. Number one, invite me over. I love wine. Invite me over to share in that bottle, but that is not going to be, you have that pre-existing relationship, okay? You have that friendship. It has nothing to do with the fact that you are in office. So that is not going to be considered a circumstance where it could be viewed to try and bribe you to do something. On the other hand, if you have somebody before the board, a developer before the board, trying to get a project done, then all of a sudden they're giving you like some golf passes left and right, taking you out for dinner. Ooh, yeah, that does not pass the smell test. On that note, I'm going to, yeah, that is ethics in a nutshell. Happy to answer questions. Call AOT's offices, call NICOM, call NISAC, and that's what I have for you guys on ethics.
Thank you. Everybody still good?
Just going to pull up our next presentation. Did that work?
Green did not share.
Oh, it did not?
Nope.
Okay. Let me. Okay.
Also, and this is an opportunity if you happen to be somebody who is affiliated with a city or a village and you're not interested in town government, this is going to be mostly town government focused. You may have an interest anyway, but thank you for joining us in the event that this is not something that's of interest to you.
Yeah, and I hope that you learned a thing or two from ethics. If nothing else, that my cat is awesome. Anyway, Lori, take it away.
Okay, so this is just going to be an overview of town government. Very general in nature, not going to do a deep dive on any of these topics. It's really intended for somebody who is a first-time town official or somebody who is maybe on the planning board and now finds themselves the town supervisor or on the town board. It's not a deep dive. It's a bird's eye view from way up high. Next slide. Okay, so towns are general purpose local governments. They're in the same category as counties, cities, and villages. They all have the authority to regulate conduct, provide services, and to levy taxes. And they are multi-purpose local governments. So that's the general overview. Towns are typically created by statute. There may be an example or two where they're created through a court action, but generally you're going to see they're created by statute, either by the state legislature through a special act of the state legislature or through a process actually provided for in the town law. Next slide. Okay, so there's 3 classifications of towns: second, first, and suburban. Mostly these are delineated by population and assessed value. With the advent of the Home Rule Law in the 1960s, a lot of the distinctions between the classifications are no longer applicable, but generally speaking, the smaller your population, the less services you originally had to provide and the less positions you needed to be able to do that. Next slide. Okay, so here's a list of some of the most common services that towns provide. You own and manage roads and in some cases bridges. You have town courts. You may do that individually, or your town may have done a consolidation initiative. I think there's a few towns up in the Tug Hill region that have consolidated their courts. You issue various licenses and permits. You do have the authority to do planning and zoning. You can provide public protection, and under that category, you're going to see law enforcement, emergency services such as fire or ambulance. You also have the authority to provide water and sewer and parks and recreation. Next slide. Okay, so town services are provided either town-wide, part-town, or through special districts. Sarah's going to talk about special districts briefly, but I'll focus on town-wide and part-town. This is most applicable if there happens to be a village within your town. Next slide. Okay, so if you don't have any villages, then everything's going to be either a town-wide service or an improvement district service. So examples of town-wide services when you have no village would be your highway services, that's operation of your highway department and your roads and bridges and drainage associated with those. Your assessor and board of assessment review, if you have a police department or you contract for extra police services, planning and zoning. This is going to be a service. These are services that will be provided town-wide and will be charged town-wide. Next slide. If you happen to have a village, that's when the part-town, town-wide services and expenditures and taxation becomes more relevant. So here, there are some towns that do have villages within them. A village is, although an independent local government, it has to exist within a town. So there are metrics that have been put in place by the state legislature to address what services are provided by the town, what services are provided by the village, and how do we pay for those services and who's taxed for those services. So examples, if you have a village, a townwide service would probably still be your police department, although there is a narrow exception. Assessing services could still be at the town-wide level. Always are going to be part town services that the village is not taxed for, nor are the town's planning and zoning codes applicable within the village. That would be planning and zoning and certain highway repair and maintenance. Next slide, please. Okay, Sarah, you're up. Districts.
Okay, so Lori had mentioned special improvement districts, and those are like, if you think of the circle that is the town, special improvement districts, they can take up the entire town. It can be like one district that covers the entire town. It's more than likely going to be like a bunch of little districts. So like a bunch of like little circles within the big circles and overlapping circles. Common special improvement districts include providing water and sewer fire protection in towns. Only the people who live within that special improvement district are going to be paying for those services. So that is not like, if you do not live in water district number 14, you are not going to be paying for water district 14 water. Only the people who live within that district pay for and receive that service. So there are two different ways that districts can be created. One is by residents can petition to have a district created. So you might have people in your community who really, maybe there's been like some development in a certain area and they're like, hey, you know what, we really need municipal water in this area. So they can petition the town board to develop a water district, or the town board can, by its own initiative, create a special improvement district. And there are a bunch of different types of special improvement districts. I think they're listed in Town Law Section 198 primarily. Water, sewer, fire protection are just some of the most common types of special improvement districts. You can also have lighting districts, garbage, ambulance districts, things like that. So yeah, it's just like a small subset of the town in most cases, receiving a very specific service, and only those residing in the district pay for and receive that service. Towns provide a lot of services, and you know, Lori went over some of them, and we're going to get more in depth into that. But how do we pay for those services? How do towns get the money to pay for those services? There are a couple of different sources of revenue or income, ways that they get the funds. There's state and federal aid. So some of the most important state funding is called AIM. Aid and incentive to, that stands for aid and incentive to municipalities. And you might have heard of CHIPS funding before, and that's for highway funding. So AIM funding is general use. It's distributed pursuant to a formula. And you can use it pretty much for whatever. The town has a large amount of discretion with respect to how they want to use that. CHIPS funding is specifically supposed to be used for highways, local highways. And then there's like Bridge New York, Pave New York, all sorts of different pots of money that the state distributes for specific purposes. But CHIPS and AIM are the two big ones. Federal aid, you might have heard of ARPA money, the American Rescue Plan Act money, or the state and local SLFRF. But ARPA money, that is money that was given to local governments by the federal government as part of a COVID economic initiative. And municipalities have a bunch of different ways that they're able to use ARPA money. So that's an example of federal aid. Also, you might get like FEMA funding, CDBG grants. So that's one source of funding. The biggest way that towns are able to pay for the services that they provide is through sales tax, real property sales tax, real property taxation. Not, oh my God, sales tax, real property tax, not sales tax. I'm so sorry about that. But real property tax, you know, that's why property in the municipality is assessed. There is a real problem with tax exempt properties, right? Because they still receive town services, but they are not paying real property tax. There are actually some areas of the state where as much as 90% of the property within a municipality can be tax exempt. and not on the tax roll. And that is an issue. You can enter into something called a pilot agreement, a payment in lieu of taxes. Some organizations or entities are open to doing something like that. But yeah, real property tax is the main source of funding for municipalities. There are also a smattering of other sources. Sales tax. Towns they do not have the authority to impose sales tax. Only counties and cities can, but most counties in the state share their sales tax revenue with municipalities in the county. There are a few counties that do not share their sales tax, and that is the option that they have, but most counties have a sales tax sharing agreement, and that is another source of revenue. There's also other types of like mortgage recording tax, so that those are different kinds of taxes. So you've got sales tax, mortgage recording tax, real property tax. Those are your taxes, source of funding. And then you've also got like your smattering of fees and rents. So like dog licensing fees, building permit application fees. Those are ways that the town gets money. However, there are some restrictions, right? There are a bunch of opinions that say that basically municipalities aren't a for-profit business, right? So if you are going to charge fees and things like that, they should be reasonable and used to, you can't be using them as a profit-making enterprise. But like a town can rent it. Let's say that it owns a piece of property that it doesn't have any use for. The town can rent that out to somebody and get money from that. But those are the main sources of funding that towns have. Going on to the administrative structure, like how a town is established. Here we have, and we're going to go through each of these. Here you've got like the town board at the center of everything, right? Because the town board is it's the beating heart of the town. It is the one that has the authority to issue contracts, do all sorts of things. And most, if not all things, involve the town board. You've also got, the spokes coming out of the town board, you've got permits and records that are, the town clerk is responsible for that, planning and zoning, highway administration, that's done by the superintendent of highways. Lori's going to talk about that. A lot of fiscal affairs are the responsibility of the town supervisor. We'll get into that. Tax assessment and collection. As I said before, real property taxation is the main source of funding for municipalities. So your assessor, your board of assessment review, and your collecting officers all play really important roles. And then there's miscellaneous administration in the town, animal control, parks and rec, emergency services, special improvement districts. There is, I should say, I should have brought up when I was talking about special improvement districts and special districts, there is sometimes a misapprehension that special districts have their own administrative board. 99.9% of the time, your town board is going to be the one who is in charge of administering special districts. So starting with the town board, they are, if you go back to grammar school and think about the division of government, you've got your judicial branch, your legislative branch, and your executive branch. Your town board is your legislative branch and also a little bit of your executive branch too. But your town board is responsible for adopting all local laws, ordinances, and resolutions. They are responsible, and that is why they are at the center of that little spoke of that little wheel. They are responsible for the overall administration of the town, and that includes controlling town financing, developing budgets, and being responsible for town property. They are the ones that authorize and approve all purchases and contracts entered into by the town, which is why if you are on the town board, you have control over a contract as that term is defined under GML Article 18, as I went over before. So yeah, the town board is the one in charge of approving all contracts. They are the ones who appoint most officers and employees and set the salaries for those positions. I say most because there are a few exceptions to that rule. So for example, deputies are appointed by the principal. By that, I mean the deputy supervisor is appointed by the supervisor. The deputy town clerk is appointed by the town clerk. The deputy highway superintendent is appointed by the highway superintendent. Deputies are appointed by their principal. The town board exerts some control over those positions though, because they are the ones who hold the purse strings, okay? You hear that about Congress, right? Congress holds the purse strings, so The town board is the entity that holds the purse strings. They're the ones who set the salaries for these positions. They also set policies. So your employee policy, your sick leave policy, health benefits, that is all a decision of the town board. As I mentioned before, they are also the entity that creates and administers special improvement districts. What's important to know about the town board is that they can only act as a body. No one individual town board member has unilateral authority. So it is very different than, sometimes people think about like the supervisor being like the equivalent of a village mayor. That is not, it is the town board. The town board acts as a body. You need a majority of the town board to accomplish anything. No one member of the town board can enter into a contract, can make a policy determination, can set a salary, anything like that. The town board can delegate day-to-day administrative responsibilities to the supervisor just to keep the town going, like, hey, mail, for example, mail goes through the supervisor. So if it's not like a policy determination, if it's something truly administrative that is necessary just for day-to-day functioning, the town board can delegate that to the supervisor. But most town boards are 5 people. You need a majority, so you need 3 people in most instances to get anything done. There is the rare occasion where you need a supermajority. I don't want to dwell too much on that, but just in 99.9% of times, you are going on a 5-member board, you are going to need 3 people to agree to something in order for the town board to accomplish anything. Let's say that there's a vacancy on a 5-person town board and you have 2 votes yes, 2 votes no. No action, guys. Like, you can't move forward. You need a majority of the town board from the 5 seats. It's not like if there are 4 people, then you only need 2, or if there's 3, let's say that there are 3 members on the town board and there are 2 vacancies, you still need all 3 people to vote yes. You are always going to need a majority of the board. The board acts as a body. Some of the other authority that the town board has is they are responsible for designating depositories, establishing investment policies, approving budget transfers when we're talking about fiscal administration of the town. And as I said before, they approve all contracts and expenditures. They're the ones that hold the purse strings. The supervisor has some additional fiscal responsibilities, but not necessarily more authority. So the supervisor is responsible for the custody and care of town funds, to execute contracts. They don't have the authority to make the determination on whether to enter into a contract. The town board does that as a body, and the supervisor is an equal member of the town board. But by execute the contract, I mean sign, basically. But it's the town board directing the supervisor to sign a contract, to disperse money. They are not able to do that of their own accord by, just saying like, oh, you need permission. It needs to be a decision of the board. And it is the supervisor's responsibility to keep accurate financial books. And I'm going to turn this over to Lori to talk about tax collecting.
Thanks, Sarah. Normally, our colleague Katie would do the next 2 slides, tax collection and assessing, but I'm going to do them tonight. This is not my area of expertise or comfort level, but I think I can get us through a basic overview. So Sarah mentioned how real property taxes are one of our main sources of revenue. So somebody's got to collect it, right? And that person is known as either the tax collector, the receiver of taxes, or in about 75% of the cases, it's the town clerk. And it's an important function. Right now, we're in a transition period because we've just had general elections in the Tug Hill region. And so you may or may not have a new tax collector coming on board January 1st. So if you are a new tax collector tonight, I would suggest taking some time to meet with the incumbent tax collector, because it's the incumbent tax collector right now who's going to be setting the tax collection schedule for January. And that in January, you are required to collect taxes a certain number of days and hours per week. I think it's 3 days per week in January during normal business hours. And those dates and hours have to be published. So that's the current town collector, receiver, or clerk who's going to be setting those hours and publishing it. So you're going to, if you're coming in January, you're going to want to work together to make sure she can do that. You can collect your taxes when it works for your schedule. So that's very important. Another thing that's very important is the warrant. So the county real property tax director is going to issue a warrant, which is essentially the document that authorizes you to collect taxes. Only the collecting officer and the collecting officer's deputy by statute can collect taxes. So no one else can. And the warrant directs, that's your authorization to do so. It's a very important document. You want to make sure that it's either hopefully it's in the name of the office. So the warrant is in the name of the tax collector for the town of X, or receiver of taxes for the town of X, or town clerk collector for the town of X, as opposed to an individual, because if it's at a transitional period, that the warrant may not take effect until January 1st, or it might be issued in December 31st. So if it's made out to the office as opposed to an individual, that's going to be super helpful to get you going as soon as you take office. I think I covered everything there. The position can be elected or appointed, and the collector, receiver, or clerk all have the authority to appoint a deputy to assist them. Next slide. Okay, so we have to levy our taxes based upon the value of the property, and that involves two parties: the assessor, who may be elected or appointed. A lot of them are appointed now under Real Property Tax Law Section 320. They serve a 6-year statutory term of office, which is set to, the current statutory term is set to expire September 30th, 2025. So your assessor is going to be there, and one of their jobs is to evaluate and to determine the assessment of the property. That is an assessor function, not a town board function. The town board does have the authority to appoint the assessor, to provide staff to assist the assessor, setting the salary and benefits of those offices. And if needed, if you're going to do a big assessment, which is called a reval, they can provide funding for a consultant to come in and assist in that initiative. But it is the assessor who does the assessment, and they do so based upon real property tax law, certain metrics that they have to follow, and they have a calendar that they do that. So for example, they set the taxable status date, generally speaking, March 1st. They have to have their tentative assessment roll, which is the big list of how everybody's property is assessed, by May 1st. And then if somebody is not happy with how their property has been assessed, we go over to the Board of Assessment Review. Everybody who has an assessor has a Board of Assessment Review. This is an appointed body by the town board. They can be 3 or 5 members. They typically have a 5-year term of office. No one in the assessor's office may serve on the Board of Assessment Review. So if you talk about conflicts of interest and compatibility of office, which Sarah touched upon in her ethics presentation, this is an example of a statutory prohibition. No one in the assessor's office can be on the Board of Assessment Review. And the purpose of the Board of Assessment Review is essentially to evaluate whether or not the assessor properly assessed a person's property. So if you disagree with your assessment, you would first go to the assessor, see, if they missed something or didn't know about something. And if they're like, nope, I like, what I've done here, I think that this is the correct assessment, you can then file what's called a grievance with the Board of Assessment Review. They typically meet towards the end of May. And then they have the ability to adjust the assessments. And then there's a process where you can take it to the courts if you're not satisfied with what the Board of Assessment Review has done there. I think you're up, Sarah. We're on to planning and zoning.
You're muted, Sarah.
Okay, sorry about that. Trying to do like 90 things at once. Okay, planning and zoning. You have land use is one of the most important things that towns do. And that involves a couple of different characters, right? So land use can, with their authority to regulate land use, towns can do things like adopt local laws on the height and size of buildings, the density of lots and the size of yards, the location of buildings. You can create zones and say that, only commercial buildings can be developed in this area, only residential buildings can be in this area? If you're going to build a new structure, how far does it have to be set back from the road? It is important to remember that land use laws, local laws, are how the land is used, not who uses the land. But one of the main authorities that towns have is to adopt local laws on how land is used. Also, Lori, I just want to mention that I was in the middle of typing up the answer to that executive session question. So I'm on top of that. But yeah. Okay, so land use laws and like the administration of land use involves a bunch of different characters. You've got the town board, and they're the legislative branch. They're the ones who adopt the local zoning laws and ordinances. They adopt a comprehensive plan. The comprehensive plan is sort of like the vision statement for how the town is going to develop. And when a town board is adopting land use laws, it has to be in accordance with the comprehensive plan. Okay, you can't have a comprehensive plan that says that the town of Opha Springs is dedicated to open space and then adopt a bunch of local laws undermining that. Okay, your local laws have to match up with the comprehensive plan. The town board is also the one who is responsible for appointing members of the planning board and the ZBA, and they also appoint the code enforcement officer. If you have zoning, if you have land use laws in your town, you are required to have a zoning board of appeals. Statutorily, under Town Law Section 267, zoning boards are responsible for taking a look at variances. There are two different types of variances. There are area variances and use variances. Area variances are, I want to do something, but I don't have enough land. So I still want to do it. Can you make an exception? Variances are like, can you make an exception in this circumstance? So the Zoning Board of Appeals is the one that reviews those applications. The Zoning Board of Appeals is also responsible for interpretations and any other responsibility that is delegated to it by the town board. So traditionally, in most towns, I would say something like a special use permit tends to go to the planning board. However, towns do have the authority to issue that responsibility to the Zoning Board of Appeals if they want. But mostly Zoning Board of Appeals are appellate bodies. By statute, that means that they only review something once it's been they only review something once it's already been looked at. They very rarely have instances where they look at something in the first instance, unless the town board says that. The planning board, a lot of people don't know this, and this comes as a surprise. Towns are not required to have planning boards. A lot of them do. But there's nothing unlike zoning boards of appeals that says if you have land use laws, if you have zoning laws, then you have to have a ZBA. There's nothing that says that you have to have a planning board. But a lot of towns do. Planning boards are created by the town board, and they do not have any inherent responsibilities. There's nothing in town law that says planning boards do X, Y, and Z. Town boards are the ones who actually get to make that determination on what planning boards have authority over. A lot of times planning boards are charged with helping to prepare comprehensive plans, doing things like looking over subdivision applications, special use permits, things like that, participate in site plan review. It is really important to know that unless the town board reserves the authority to override decisions of the planning board, if a planning board makes a determination, that's it. The town board does not have the authority to come in and be like, hey, we don't actually agree with what the planning board decided, so we're gonna change that determination. Unless the town board has specifically reserved the authority to do that. When it comes to the Zoning Board of Appeals and variances and interpretations of the code, the town board never has the authority to override a ZBA determination on variances and interpretations. That's a statutory thing. So who the town board appoints to fill the ZBA and the planning board is really important, because they don't have the authority to come in and be like, we don't agree, changing our mind. If they have delegated the authority to the planning board to make that determination, the buck stops with the planning board. Of course, the town could always pursue an Article 78 procedure to override that, but that would be the town suing themselves. And it's not unheard of, but it's not common. And then you have your code enforcement officer, and they're like the boots on the ground. They are the ones who are responsible for enforcing zoning laws, issuing permits. And then, what I had said before in the ethics presentation, talking about reviewing your own work. So your code enforcement officer shouldn't be on the ZBA because they would be reviewing their own work. They would be reviewing whether a permit should have been issued or not. But yeah, so there are a bunch of different players. There's no one size fits all with land use and how towns address land use. As I said, some towns have planning boards, some towns don't have planning boards. Some towns reserve the right to review planning board decisions, some towns don't. Some towns give, the zoning board of appeals the authority to take a look at special use permits. There's no one size fits all. So if you are new to office and you were taking a look at how your town does something, and you're, giving the side eye to your neighbor, being like, oh, well, how do they do that? If they do something different, it is not wrong, and you are not necessarily doing something wrong. It's just that there are so many different ways to do something. The law allows for so much flexibility in how to achieve this, so that it's not a one size fits all solution. And yeah, planning and zoning is a really good example of that. And how your planning and zoning is structured within your town is going to differ from town to town. Turning this over to Lori on highway administration.
Oh, highway administration. I like this topic like Sarah likes ethics. So every town, for the most part, has a highway department. That highway department is overseen by, in most cases, an elected highway superintendent. About 10% of towns have gone through a home rule process to convert the office from elected to appointed, but by and large, you're going to see that the highway superintendent is an elected officer and is also a department head. As such, the highway superintendent has authority directly provided to that individual from a state statute called the highway law. So here's some examples of what they're generally responsible for: the repair and maintenance of highways, snow and ice removal on highways, care, custody, management, and control of highway machinery and equipment, and then employees who are on the road crew. So in the highway department, you have two groups of employees. You have the employees who fall within the labor class, or MEOs or HEOs. They're the folks that actually work on the roads. They plow the snow, they fill the potholes, they deal with drainage issues and things that are actually on the roads themselves. And then you have another group of employees who sit at a desk. They're, essential as well, but they're grouped differently. And so highway department employees who work on the road crew are funded by the highway fund and hired, supervised, directed, disciplined, and if necessary, removed by the highway superintendent. There's all kinds of rules and regulations that have to be followed. And administrative employees are actually funded by the town general fund and hired, disciplined, and removed if necessary by the town board. So there's two groups of employees in the highway department. They both provide essential services. The town board, like Sarah said earlier, holds the purse strings. They develop the budget. The highway superintendent, as the department head, would submit a budget estimate, but it is the town board that actually determines what the budget will be. And the highway superintendent has to work with that budget. Sometimes, and it's not at all unusual, that the budget will not have the revenues to support the appropriations that folks thought, 6 months prior. And so you can do budget transfers. Sarah talked about that a little bit with the fiscal administration, if necessary. And one of the critical things that needs to be done, and may come to the town board in January, is the 284 agreement. So the 284 agreement is where the highway superintendent and the town board sit down and work out, sometimes it's called the paving contract, what roads are going to be improved during the spring, summer, and early fall construction season. And so the highway superintendent needs that document in place as early in the year as possible so that they can hit the ground running in terms of planning and purchasing. If sometimes folks have difficulty agreeing on what projects are necessary, a couple of important things to remember: it can be modified by mutual agreement of the supervisor and the highway superintendent and a majority of the town board. if needed. And also, if you have a weather event, that a road gets flooded out or something like that, that you were not intending to address in that particular year, you can go back and modify it, take some projects that were scheduled to be worked on off the 284 agreement and add new projects. And it's the same process. It's a mutual agreement between the highway superintendent and a majority of the town board. Next slide, please. Okay, Sarah touched upon permits and licenses. Towns license a lot of activities, some by statute, some by local action. And usually speaking, it's the town clerk who's going to be the permit and licensing issuing officer. There may be exceptions. Building permits, for example, are commonly issued by the building inspector or the code enforcement officer and not the town clerk. The town clerk does a lot of other stuff, though, in terms of issuing licenses and permits. By statute, they do marriage licenses. If they're also designated the registrar of vital statistics, they'll do birth, death, and burial permits. Those are all state statutory permits. That you may have a junk dealership license or they do going out of business licenses. I think Sarah mentioned dog licenses, and then through the Department of Environmental Conservation, there are hunting and fishing licenses. Those are just some examples, most of which are issued by the town clerk's office, again, with some exceptions. Next slide, please. Okay, so records management. This is a big topic that we see for transition years, particularly because when a town officer leaves office, which in most cases this year will be happening December 31st, they are required by statute to turn over all of their records to the town clerk's office. There's an exception for the courts. They have their own records retention schedule and process, but everybody else, they turn their records over to the town clerk's office. The town clerk is the statutory records management officer. Archived records are filed in the town clerk's office. The town clerk is responsible for overseeing the preservation and destruction of records pursuant to something that's called the local records retention schedule. State Archives has individuals who can answer questions. They have a great resource on their website, lots of information there. So if you have any questions about records management, go to State Archives. They're a fantastic resource. And then there is a provision in the Public Officers Law that if it's necessary, if you know that records are missing and you need to get them, you can send a request letter to the former town official asking them to return all of the records. Sometimes people don't even know they've got a box of records in their garage. And, you send them a letter and they're like, oh, I better go look. And they go and they look and they find the records. And if necessary, you can get a court action, to facilitate that if it's needed. Next slide, please. So we're just past 8 o'clock, so I'm going to zoom through the next couple of slides. If that's okay, Jennifer. I think we're supposed to end at 8. If folks have just a few more minutes of stamina, I think I can get through this. Is that okay, Jennifer?
Sounds good to me. I understand if you have to get off, folks, but yeah, go right ahead.
Okay. Sarah touched upon a lot of these when she had her initial, administrative overview of the town government, but just to do a little bit of a deeper dive, towns are responsible for animal control. It used to be exclusively within the jurisdiction of the town, and now the state has broadened who can provide that authority. So you're either going to have your own dog control officer, or you might contract with the county, or you may do an intermunicipal agreement with neighboring municipalities to share that resource, or you might go to a local, is it called ASPCA? I think that's what it's called, a humane society, and contract with them to provide that service for you. You may or may not have a shelter, or you may contract with an organization or the county for shelter services. And so you're going to have your own local dog licensing law, and a lot of municipalities go beyond that, and they have leash law rules on the books as well. And then you're also going to be responsible for Article 7 of the State Ag and Markets Law. If you need more information on that, there's a chapter on licensing in the town clerk's manual, which hopefully is in your office. Recreational services, I think Sarah touched upon this a little bit. You can, but are not required to offer recreational services. You can do this through a recreation commission, which is appointed by the town board, or through a department, or you might have a park district. There's different ways that you can offer this service. You can provide services to senior citizens under state law. You can provide services to children under state law. You can provide cultural services such as band concerts. You can sponsor museums. There's all kinds of things that you can do under the umbrella of recreation. And Sarah talked about improvement districts, so we're going to whiz by that one. Next slide, please. Emergency services. So emergency services have three kind of buckets: police, fire, and ambulance. You have the authority as a town to have your own police department. You may choose to contract with the state troopers or the county sheriff for additional services, or you may just rely upon the services that are provided by the county or the sheriff. You've got some options there with respect to police services. Fire services, towns cannot provide fire as a town service. It has to be provided through a district. Sarah talked about districts earlier. It's either going to be a fire protection district managed by the town board, or it might be a separate independent district, like a fire district, similar to a school district. It's a single purpose, separate district governed by its own separately elected boards. But the town does have some overlap there in terms of levying their taxes. And then ambulance service is a service that the town can provide itself, or it can provide it through an improvement district. The Tug Hill Commission has a great white paper on their website about ambulance service. It's a pretty complicated topic. There's a lot going on with ambulance service right now. You don't have to provide ambulance service at the town level. Many do. And commonly it's done either as a townwide service under a state statute called General Municipal Law 122-B, or through an improvement district. And Sarah talked about that a little bit ago. Next slide, please. The next few slides are about oaths of office and undertakings. So if you are newly elected, you have 30 days from the commencement of your term, so basically January 30th, to take and file your oath of office with the town clerk. Justices are also required to file their oaths of office with the county clerk and with the Office of Court Administration, which is a state agency. And again, if you're a town clerk that is also appointed the Registrar of Vital Statistics, your oath has to be filed with the county. The town clerk will notify the town board if somebody has not taken their oath of office, but they have no obligation to notify an individual to take their oath of office, although many town clerks will do so as a courtesy. And your oath of office is good for the entire length of your term of office. Next slide, please. This is a list of folks who can administer the oath of office. So the town clerk, any notary public, certain judges of the Court of Appeals or the Supreme Court, the supervisor, but curiously, the supervisor's authority is limited to members of the town board and the town justice. Next slide, please. So in addition to your oath, certain individuals who handle money are required to have what's called an official undertaking. It's essentially an insurance policy. And what it is the town will contract with an insurance company, a third party, who will come in and make the town whole in the event that money is lost or stolen. They're a guarantor, if you will, of restoring lost or stolen funds. Next slide, please. These can come in different forms. It could be an individual undertaking that's going to cover the individual or the office. More commonly, you see them as what's called blanket undertakings, where the town will get an insurance policy that covers everybody. The town determines in either case the form and the amount, and then failure to do so within 30 days of taking office, just like your oath, will automatically vacate your office. The town clerk usually keeps track of the undertaking and will notify the town board if it's set to expire so that it can be renewed. It is a general fund charge. These are pretty typical and easy to manage. There's very limited circumstances, I think, where an individual has difficulty getting an undertaking. In the event that happens, they need to work with the town board to make sure, if they're going to be looking for their own independent insurance company, that the town is comfortable and approves the form and the amount. And it should be a New York State licensed company that is providing that service. Next slide, please. So here's by statute, those who are required to be covered by an undertaking. And again, these are folks who touch money: the clerk, the supervisor, the highway superintendent, the collector or receiver constables, and judges, and then anybody else the town board thinks should also be covered. And again, most folks do the blanket bond and cover everybody. Next slide, please. And again, this is just another cautionary note. Failure to do this in a timely manner, which is 30 days from the date of the commencement of your term, will vacate your office by operation of law. If you are an elected official, you do have the ability to take and file your oath early, as long as the county has certified your election results. So if, for example, you're lucky enough to be on a cruise during the organizational meeting, which is when a lot of folks do their oaths of office through like sort of a ceremony or, a nice little event, you can go ahead to the town clerk's office or the town judge and get it done ahead of time, as long as the county has certified your results. That's all I got.
Thank you. That was a lot. There's a couple questions in the chat. If you want to go ahead and take them, go ahead. So to encourage one, or if one wants to answer the question, if you want to put a link to, again, to your conference and the dates and times, and I'll do the same while we're answering the question.
It looks like this one might be something I can handle. From John. Do I have to take the oath of office again if I'm already sworn into office? That depends on whether you have been elected to a new term of office. So we just went through a biennial election cycle in the Tug Hill region. In the event you are starting or commencing a new term of office, January 1st, you will need to take and file a new oath of office as soon as you commence your term, or again, you can take it as soon as the Board of Elections certifies your results. Failure to do so within 30 days or January 30th will result in you vacating your office. So it's important to get that done. And that oath will be good for your entire term. Oh, I was appointed and sworn in and also won my election. Oh, I see. So it sounds like this person may have been an appointee who was filling a midterm vacancy and then ran for the remainder of the unexpired term. The oath of office that you took was for your appointment, and that appointment expires December 31st of this year. Again, you're elected to fill the remainder of the unexpired term or a new term, depending upon the timing. You need to take a new oath of office for the January 1st commencement. Oh, they're coming fast. Okay.
I'm going to let you take the one on undertakings.
How often do you have to do an undertaking? If there are staff changes, does another need to be done? And if it was a blanket undertaking, one would be just for the individual to do it. Okay, so a blanket undertaking is going to cover everybody. And the town clerk is going to manage that in terms of when it's set to expire and notify the town board so they can renew it. It's probably not going to address individuals. It's probably going to address everybody who works for the town, who's employed by the town, who's elected, appointed. And so that's just a rolling document, but you want to make sure when you take office that it's current, and that if it's a blanket, that it's a blanket undertaking. If it's an individual undertaking, which sometimes is the preferred method for certain towns, that's just the way they do it. You want to make sure that it covers you as an individual and that it's current. And so you can talk to the town clerk about that. They are responsible for notifying the town board when something is set to expire, so they should be able to answer that question for you. Are there more questions? Or did we
I went through, I scrolled back up and I think we got all of the ones that were already there. Just if anyone has new questions coming in. Okay. There's a question, is there any training available regarding the myriad wind and solar projects and potential conflicts with agriculture and forestry priorities / interests? There are, I mean, I know that solar and wind projects have been covered at the Tug Hill conference in the past. I would take a look at their agenda, the Tug Hill Local Government Conference agenda when that is posted. It's a great conference. I'm not at AOT's conference in February. I don't think we have all of our programming finalized, but we usually have stuff on renewable energy. And yeah, just just keep an eye out for stuff like that. And Tug Hill has a really great newsletter too that lets people know about webinars, things like that, because especially in the North Country, you know, we're very familiar that renewable energy siting and renewable energy projects are a hot topic there. And yeah, Tug Hill is a great resource for keeping people apprised of training opportunities on topics like that.
Yeah, feel free to join that Tug Hill Times list. So, right, when's the date of your conferences again? Are there Albany and Rochester, is that it? Or
Yeah, Albany and Rochester. So let me pull up the calendar. We will be in, wait, actually, Lori, do you know which one is Albany and which one is Rochester?
Hang on a second. I just have to open my calendar too. I can't walk and chew gum at the same time.
Yeah,
right,
no, I know.
I believe the newly elected in Rochester is January 10th through the 12th. And that's in, I think, Henrietta at the Doubletree. And then the newly elected in Albany is, oops, sorry about that, is the 17th through the 19th. And that's at the Marriott on Wolf Road, if you're familiar with the Albany area. And the annual meeting is the 18th through the 21st at the Marriott Marquis in Times Square in New York City.
Thanks, everyone. Getting close to bedtime here. I want to thank Sarah and Lori again for all this information. Thank you so much for all you do for the communities, and we'll see you at the conferences.
Thanks for
Look
having
forward
us.
to it.
All right.
Thank you.
Have a good night.
You too. Good night, everybody. Thanks for sticking with us.